Okay, we'll take up our last case of the morning, which is Madison Oaks versus Florida Housing Finance Corporation. And you may proceed.
Thank you, Your Honor. My name is Tim Schulty. I'm at the law firm of Zimmerman Kaiser Suckliffe, and I represent the appellant, Madison Oaks. I'd like to reserve 5 minutes for rebuttal.
All right, you may continue.
As you heard, Your Honor, the parties worked out in advance that because Madison Oaks issues on appeal with relation to the Manatee Charter School are identical to Sterling Terrace, for purposes of judicial economy, we're going to stand on the arguments that counsel for Sterling Terrace made, and we've advised appellee of that in advance, and I believe has no objection to that. Your Honor, the issue is the trial court's decision, which erred as a matter of law in finding that the Harper's Point development site was not a scattered site. The issue at trial and the issue before this court has always been the same. There is an easement that divides the development site into a north parcel and a south parcel. The question has always been, is that easement a street easement? Because under the RFA definition of a scattered site, if that easement is a street easement, then it's a scattered site.
Let me ask this. What appears in the record as a copy of the plat, I guess it's book 134, page 378, just says 50-foot street, but there are no words of dedication on the document that I saw. Are there any, typically in a modern plat, you see the words, the streets shown on this plat are dedicated to the public, and there's an acceptance by the city and all that. Are there any words of dedication on this plat?
I'd have to go back and look at the plat, Judge, because that was not ultimately an issue at trial. But I think I can answer the dedication question by saying this. There were 2 sales within the platted subdivision. And as this court, the 5th DCA, held in Enos versus Casey Mountain, when somebody buys a lot within a platted subdivision, they have an implied street easement over the platted streets.
But accepting that to be the case, doesn't the current, aren't both sides of this easement, let's call it a street easement, or, we all know we're talking about that strip, aren't they in the same hands now?
No, Your Honor.
They control, the same party. Doesn't the applicant control everything on both sides of that easement?
No, they do not, Your Honor. So there's 2 sets of deeds. The first set of deeds are petitioners' exhibits 14 and 15. Those deeds establish that there are 2 landowners within the platted subdivision that have access to that street easement. There's a second set of deeds, which is exhibit P13. And in that landowner was given an express easement. In his deeds, or actually it's a corporation, WJJR, they were given a right of ingress and egress over the platted streets. By law, that's an express easement.
But that assumes that there are platted streets, and which brings me back, and again, I recognize that apparently, for whatever reason, the parties didn't raise the issue, but I'm trying to understand if these streets were ever dedicated to the public, or if there was a common law dedication which requires acceptance and maintenance. And I think we can all agree that there's apparently no street there and it's got vegetation. Apparently the evidence is you couldn't run a car over there.
Yeah, I think that's accurate, Judge. I'd say 2 things. First of all, one of the parties in this litigation actually raised the validity of the plat. It's a very old plat, and one of the parties raised the validity of that. They ultimately determined, and I think accurately, that they could not put on evidence that that plat was invalid. So some of the issues you're talking about were initially pled, and then ultimately the parties decided they couldn't pursue those issues. I'd also point out to the court, and I believe this is in Enos versus Casey Mountain, that even if ultimately the plat is invalidated, the location of the easements, if they can still be determined by a surveyor, then those easements are still there, especially the express easement to the one landowner. Your Honor, the standard of review when you're looking at easements is de novo. Easements are created by deed, and we didn't. I realized yesterday that we hadn't actually cited to the court a standard of review case on easements, and maybe I'm overthinking this, but I thought I would give you one, and I've given it to counsel. The case of Hasty versus Ecom, 199 Southern 3rd, 461, says that this court's review of the deeds and the easement in the deed is a de novo review. So if you look at the deeds that are exhibits P 14 and 15, they create an implied street easement. And if you look at the deeds that are P 13, they create an express easement. And the issue in this case has always been, is that easement a street easement? This court has to find as a matter of law that there are street dedications of street easements over that platted street. The trial court made the same mistake that was made in another 50 CA case, Diefendorfer versus Forest Park Springs. In that case, very similar situation. It was a platted 50-foot street. Some of the owners in the subdivision had made a 12-foot dirt road. The servient landowner built a subdivision wall inside of the easement, but didn't affect the road. When the easement owners asked for a mandatory injunction to remove that subdivision wall, the trial court denied the injunction, and the court analyzed and said, well, this easement the roadway is never going to be affected by this wall that was built. The Fifth District Court of Appeals said that the trial court's analysis of future use was both irrelevant and inappropriate. And the reason it's irrelevant and inappropriate is the deed establishes the easement, and you can't build an obstruction inside somebody's easement.
Let me ask you, the definition of scattered site under the rule, has the beginning part and then says real property is contiguous if the only intervening real property interest is an easement, provided the easement is not a roadway or street. Is that definition different than one that would say, provided the easement is not for a roadway or street?
Yeah, you can tell when you read the briefs and you read the trial transcript that the parties struggled with the sort of awkward wording. It's almost like words to some degree are left out. But ultimately, both the appellant and the appellee agreed on how to define a scattered site. And if I may, there's a number of citations I could give the court, but let me just read from the answer brief. Petitioners have alleged that the platted street constitutes a roadway or street easement. If this is in fact true, then the east-west road easement would bisect Harper Point's proposed development site, and the site would meet a definition of a scattered site. So that was the appellee's position before trial, after trial, and in this appeal. And they clarified that. In the answer brief, it says on page 18, the determination as to whether a proposed development is a scattered site is not dependent on whether or not a street or a roadway actually exists. The existence of an easement is enough. Now, why did appellant and appellee get to that same conclusion and try this case based on that understanding of the scattered site? It's because if you read the definition, it's looking for intervening real property interests. So what would be an intervening interest? There could be a fee simple, there could be a life estate, there could be a remainder estate. Those are all intervening interests.
But an easement for a roadway or street, it wouldn't matter if the roadway or street existed at that time.
That is correct, Your Honor.
And then what we have to deal with is the language, easement is not a roadway or street, whether that is intended to mean the same thing as if you had the word for, or whether it's looking at existing use.
I would disagree that that is the issue before the court for this reason. The parties pretrial and in this appeal have stated that that is not the issue, that construction, that the conclusion of whether or not there's an intervening interest is not dependent on the construction. So as a result, the case was not tried based on, let's say, those pleadings.
Well, the school, I'm almost reluctant to bring in the issue of the public schools, but, we just heard argument where the agency took one position at trial and then the board went the other way. So are we bound by the position that the agency took at the hearing versus what the ALJ did and what the board did?
Let me answer that in two ways. One, I think this court is bound by the pleadings and by the stipulations and the statements that were made at trial. The court was cited Palm Beach Community College versus the Division of Retirement, and also Kerr versus Helene Transportation. Both of those cases say that, the things that are said in the pretrial statement and the admissions of the parties during the trial can't be ignored by the trial court and can't be ignored by the appellate court. So that would be the first response. But then the second response is, just like in the Manatee Charter School, if the court comes up with a different interpretation than the parties pled and tried the case on, well, then there's a lack of procedural due process. You don't have your witnesses, and you don't have testimony, you don't have the argument to address where the court is going, which is why those cases say that this court should not go off in that direction.
So is what you're saying then that we don't even need to concern ourselves with what is the definition of a roadway or a street? It's just the fact that it appears on the plat, and even though it's imprecise, the easement is there, period. Correct?
Yes, Your Honor. This court does not need to concern itself with the definition of a road or a street. What this court needs to consider is the definition of a street easement or a roadway easement. And that was a mistake that was argued, I believe, in the appellee's brief. They put on a witness to talk about what a street is. They've cited to the dictionary definition of a street. Nobody has objected to those definitions of street. The question is there a street easement? And an easement is an intangible. It's a type of an ownership interest. You can't build a road across somebody's property and say, aha, I have an easement. The easement is created by deed, and I cited the court to that case, the Hasty versus Ecom case. And it specifically says easements are created by deeds, not by construction. Any more than I can build a fence around a piece of property and say I'm the owner of the property because I built the fence. Construction does not equal easement in this case. Your Honor, because the court made the Diefendorfer error, in other words, the court looked at, and I should say this, some of your questions have sort of assumed that the trial judge said, I read the rule to mean that there has to be a constructed street or a future constructed street. But the court never reached that conclusion. There's nowhere in the trial order where the judge says, I'm going to go off on a different direction. I don't agree with the parties. I think that the rule is asking, or the RFA is asking, whether there is actually a street constructed. What the trial order does is it lays out everything that the parties had said, but then in paragraphs 52 and 53 says, I'm going to take this argument about the easement. The court doesn't deny that there's an easement there. The court just goes further and says, no street was ever constructed, and I don't believe any street will ever be constructed. That was the same mistake that was made in the Diefendorfer case, in which the 5th District Court of Appeals said that analysis, that extra analysis of whether this road would ever be built is irrelevant and inappropriate.
Okay. You have 4 minutes. Do you want to save the rest?
I will save those, Your Honor. Thank you.
Okay.
May it please the court, again, my name is Chris McGuire with Florida Housing Finance Corporation. Where to begin? Right before the trial happened, up until a day or two before that, all the parties were fighting back and forth about, is this a legitimate plat? Is this a real easement? Has it been dedicated? Has it been abandoned? And all that kind of stopped a day or two before the hearing when the Harper's Point representative said, all right, we're just going to concede that there is an easement out there. It hasn't been dedicated. It hasn't been accepted by the city. It's never been abandoned. It's an easement. Okay. So the ALJ granted a motion in limine saying, I'm not even going to get into whether it's valid, whether it's going to be valid down the road, et cetera. So all we're looking at is there is an easement out there. It says street on it. Our scattered site definition says that an easement that is a roadway or a street. We have interpreted that pretty consistently as though there were the word for on there. In other words, an easement that is for it, the roadway does not have to be constructed as of the application deadline. Now the reason for this is that scattered sites involve a couple of, 2 or more parcels that are separated by property or by a road, something that impedes the tenant's ability to go from one parcel to another. And that's why we look at scattered sites. There's, amenities have to be done in certain ways, development points have to be done in certain ways. There are a lot of ways to sort of scam the system using scattered sites if we don't have some kind of control over it. But the easement out there now, even though it says it's for a street, the evidence is pretty clear that it's never actually going to be a street. So whatever rights the landowner there may have in that easement, it's never going to be constructed as a street. There's nowhere for it to go. It's a road to nowhere. So looking at it from the perspective of Florida housing and why we care about a scattered site, if there's no street there, if there's only an easement, it's not going to impede the ability of tenants to go back and forth between the parcels. They can walk across it. They own the property. They own the entire parcel. There's an easement across it, and if there's no road, there's no impediment, so it doesn't really matter to us. When you look at that Diefendorfer case, if I said that right, that talks about putting an obstruction in the road or in the easement. And the issue here is not whether or not they will be able to construct something over the easement. That's not the point of the scattered site. It has nothing to do with that. It's a matter of whether the sites are contiguous or not. So the fact that there may be some constraint on what they can build in that easement down the road, the same can be said of a utility easement. You may not be able to build exactly what you want over that utility easement. It may constrain the way you design your facility. It doesn't make it a scattered site. So the fact that the easement may continue to exist, even if a road is never actually constructed, doesn't, again, have anything to do with whether the pieces of property are contiguous or not.
So for purposes of this case, you're agreeing that that sentence should be interpreted as provided the easement is not for a roadway or street?
Well, that's the way that Florida Housing interpreted it. I believe that's the way everyone else also looked at that. That, because we do have a concern, if there's an easement out there that could become a street, it would still have the same effect down the road of dividing the property and making access between the two parcels difficult. So we don't necessarily just look at it as being in existence as of the application deadline. Often we do, but in this particular case, we've interpreted that to mean if there's an easement that really could turn into a street, really could be an impediment to traversing between the parcels, then yeah, I think you should call it a scattered site and make sure that you've done all the...
So your argument for affirming the ALJ is that the ALJ is finding that it's unlikely to ever become a street or roadway?
The ALJ found that it was not a scattered site, and the ALJ listed several reasons for that. Not super clear about exactly how they all fit together, but the reasons being it wasn't built, it wasn't used right now, and it was not going to be built because there's no ingress or egress. It's a piece of land that will never serve the function of a street. It'll never be open on either end. So taking all of those things into consideration, that's what she found, is that based upon the totality of the evidence, this is not a scattered site. You couldn't say that it was just one particular thing that led her to that conclusion. I don't think there's any doubt, really, that this is not ever going to be constructed as a street. I mean, the appellant's own witness said, based on my observation, it would not tie into anything. There's no access aligned with the east-west corridor, and it never will be. In fact, when the board of directors for Florida Housing looked at all this stuff, the comment that they made was, this looks like a road to nowhere, and upheld the ALJ on that. So, again, what is a street or a roadway for the purposes of the scattered site definition? It's something that is actually going to have traffic in it. It meets it. All we have, again, is a dictionary definition. No one's ever defined street or roadway in the rule, statute, or in the RFA. So if all we're looking at is a dictionary definition, a street's a thoroughfare, it's open on both ends, it goes somewhere, it provides ingress and egress. That's not what you have. What you have here is a paper easement, and it's a gotcha. You know, it's like, this isn't a real issue, but it's a way that we can maybe knock someone out and get funded. So the definition of scattered site is actually found in a rule. The ALJ did not defer to Florida Housing's interpretation of that. Our interpretation of that rule was pretty vague at the hearing. We basically said, gosh, I don't know. Based upon just the paper we have in front of us, all we know now is that there's an easement and it says street. I guess it's a scattered site. It wasn't until hearing when the witness testified, oh, by the way, did you know that there's a development over here? And there's some constraints on the construction over here. So we found all that out at that point. And the point of this being that reviewing how that rule is interpreted actually is de novo now. So you don't feel compelled to defer to the agency's interpretation of what that is. But really, the only way that makes sense is to look at this in the context of saying, why do we call it a scattered site? What is being impeded here? How is this affecting the facility in some way? That's...
All right, thank you. Mr. Schulty, if you prevail on this argument, your client still only gets relief if you prevail on your other argument as well?
That is correct, Your Honor. Okay. That is correct. I'm hesitant but I have to address the argument that this is a road to nowhere. That issue was never tried. It was never pled, and it was never tried. I actually think this road, there is a westerly termination of this road, but it grants easement access to the north and the south parcel. It also grants access to a road that showed on the plat and that showed on the survey that goes north and south. The south terminus of that road is University Avenue, which is one of the main thoroughfares in Gainesville. But none of that came out in the record because that was not the issue that was tried. And it would be procedurally inappropriate to now start trying a case that the witnesses weren't and the parties weren't on notice of. Your Honor, the question of that was brought up is, hey, even though there's not likely to be, even if there was a road here, it's not going to interfere with this development. I can't remember the exact number. It's either, I believe it's 5 or 6. Plaintiff or petitioner's exhibit 5 or 6 is the site plan that Harper submitted to the city of Gainesville. In other words, they said, here is how we're going to build on this property. That site plan is in evidence. That site plan shows that there is buildings, parking, and retention that is going to be built right on top of this platted easement. Those things can't be built if that is a street easement. But again, none of those issues were tried in the case because everybody understood, and I believe even the trial court understood that the issue is the easement a street easement? The court just went one step further, as Appellee did today, and said, hey, it's just not likely that there'll ever be a street here or it's not going to obstruct. But that was not the issue that was tried, and it can't be tried today in this courtroom. For that reason, Your Honor, should find that the Harper's Point development site was a scattered site because it is divided by a street easement. And this court should find that the Harper's Point application is ineligible for funding. Thank you.
All right, thank you both. And court will be in recess.